Good morning. I'd like to call this meeting to order. Today is Wednesday, July 17th, 2019. Starting the Polygraph Advisory Committee meeting. First item to go over will be the roll call. Sharon Brank, she's absent. James O'Burke, absent. Tiffany?
Present.
Manuel Espinosa, present. As you can well see, we do not have a quorum for today. Therefore, we cannot discuss any or take any action on any items that we have on the agenda for today. But we will have a meeting and be presented with some items that do not require any action item. Second order of business will be training for committee members, and that will be permissible through the Open Meetings Act. So we'll start with action item or item number C in the agenda, training. Go ahead, Elizabeth.
Good morning. My name is Elizabeth Salinas Strittmatter, an Assistant General Counsel who helps with the Polygraph Advisory Board. And I'm here today to do the required training on the Open Meetings Act, the Public Information Act, and the Administrative Procedure Act. This is training that's required every 2 years for all board members. And the board members who are not here are able to meet their training requirement by watching the training online. That link will be posted after the meeting so that those members can do that and let our staff know that they have completed the training. And for the members that are here, it's noted that you have completed your training. So today we are going to talk about, as I said, the Open Meetings Act, the APA. So you'll hear me say the APA, that's the Administrative Procedure Act, and the PIA, which is the Public Information Act. And first we're going to talk about the Open Meetings Act. And we have a perfect meeting today to talk about that because we have one of the major issues that arises with open meetings, which is having a quorum and what that means for the ability to conduct official state business. So the Open Meetings Act is an act that works very hard to achieve transparency in government. And so for that reason, it requires that any meetings of governmental bodies be open to the public and that they be preceded by public notice, and that the public be given the time, place, and date of a meeting in which official action will be taken or discussed. These are mandatory provisions, and they are strictly applied to governmental bodies, which does include our advisory boards here at TDLR. So one of the most key concepts of the Open Meetings Act is this quorum that we heard our chair make reference to. And a quorum is a majority of members that sit on a governing body, including an advisory board. And for the Polygraph Advisory Board, we actually have five seats open on that board. One is a public member, which is currently vacant. So there are 4 sitting members of the Polygraph Advisory Board, which means that in order to have a quorum, we need to have 3. Today we only have 2, so the quorum has not been met, as Mr. Espinosa stated earlier in the meeting. But even though the quorum has not been met, we can still gavel in and we can still proceed because we can meet and discuss anything that is not an official action. So in other words, anything that we're not required to vote on, that the board isn't required to vote on, and they can discuss anything that is not official business that's before them. So that is why we can continue with some of the basic routine business items that are on the agenda for today. Now, another one of the key concepts is, what is deliberation or discussion of board members? A deliberation is basically any verbal or written exchange between members of a governmental body, in this case members of the Polygraph Board, in which they are discussing any issue that is within their jurisdiction to discuss. So the polygraph members, any official business that comes before them would be considered a deliberation or a discussion, but the quorum members can sit here and talk about football all day long because that is not business that's officially before them. Meetings are very important to remember that a meeting does not have to be in an officially noticed capacity. A meeting under the Open Meetings Act is anytime a quorum of the governmental body engages in any discussion, which we just talked about, regarding public business or public policy of any issue that is under their supervision or their control. All right, so We're going to talk a little more about that in a couple minutes, but I want you to remember that a meeting does not have to happen in an officially noticed room. Okay, so we talked about notice at the beginning. Notice is required under the Open Meetings Act, and it's the time, date, and place in order to provide the public with sufficient notice that this is going to occur. And an agenda always has to be drafted and distributed and made public so that people can know exactly what we're going to talk about. That agenda, once it's finalized within TDLR, is then filed with the Texas Secretary of State, and it must be filed at least 7 days prior to the meeting and posted online by both TDLR and the Secretary of State. And a board or committee may not engage in any discussions about a subject that is not included on the agenda. So that is why oftentimes you'll see people come up during public comment period in any of our board meetings or our commission meetings, and the sitting board members or commissioners cannot comment on those public comments if they are not otherwise on the agenda. So the public can come and make any statement that they wish to state, that they wish to make, but discussions cannot be had about those comments because there has not been official notice that that discussion was going to take place. All right, so let's talk about this. A meeting occurs whenever there is a quorum of members of the governmental body, and the question then arises, can members ever meet in an informal setting without violating the Open Meetings Act? And the answer is yes. Anytime there is a quorum of members of a governmental body in a room, even if that is not an officially noticed meeting, they have to be really, really careful about what they're talking about. You can have conversations, normal conversations that are incidental to the event, but if your conversations stray into subjects over which you have jurisdiction or business pending, and a quorum of members is present, that meeting has then turned into an open meeting that is subject to the Open Meetings Act. And I'm happy to take any questions if any of the board members, I should have said that at the beginning, but if you guys have any questions while I'm talking, feel free to interrupt me. Happy to address them. All right, so what we always say here at TDLR is just be aware of any situation that's occurring outside of a properly noticed meeting and in which a quorum of members are present. Do not engage in substantive conversations relating to board or committee business or policy when a quorum is present and you are outside of an officially noticed meeting. And also be very conscious of the walking quorum. The walking quorum occurs when there are fewer members of a quorum that are engaging in a discussion about official business, and then one or more of those members goes and passes on those discussions to other members of the governmental body. So if, for example, today we have our chair having a conversation with Tiffany, and then Tiffany were to then go and send an email to another member of the board, possibly she could be engaging in a walking quorum if they are talking about official business that's before the board. So, with fewer than a quorum of members participating in the initial communication, subsequent communication with other members will result in a walking quorum. So, we just talked about what that means on a 5-member board with 2 people who are engaging in discussions. Well, what about phone calls and emails? Because a lot of people think this only applies to verbal discussions. Well, phone calls and emails are also the same thing. If you're engaging in phone calls and emails expressing thoughts about upcoming business and you subsequently communicate with another member of the governmental body, you've probably engaged in a walking quorum. And that is true even if you are forwarding messages to individual email addresses. So some people think that if they forward communications not to a group, but to individuals, that's possibly not violating the walking quorum, and that's not true. So we ask for people to be very conscious of that. Walking quorums can occur during conference calls, during video conferences, during hallway discussions that often comes up here, and through emails, text messages, and other new technologies. So we ask that our members of our governmental bodies, of our boards, be conscious of Twitter and Instagram and all of those things, and Facebook, that can reach potentially members of the other governmental board and that can be considered a possible walking quorum. Okay, so best practices to avoid a walking quorum: don't meet in small groups and discuss board or committee business and then communicate those discussions to other members. Don't send emails or text messages to quorum members regarding official business, even if the email is addressed to individuals. Don't create posts on social media about board business where a likelihood exists that a quorum could participate in the discussions, or ask quorum of members, even on an individual basis, for feedback on comments or committee or business, because that can be considered to be polling if you're talking about upcoming votes on issues. All right. Now, we've talked a little bit about what is required of under the Open Meetings Act in order to have a meeting. Time, place, and location need to be noticed, and you also have to have those specific items on the agenda. I also mentioned earlier that we can have a period of public comment during our meetings when the public can come up and say whatever they'd like to say about any subject that is relevant to the board. Unfortunately, a lot of people become disappointed when they often travel long distances and then they can't engage in a discussion. All is not lost. Please be reassured that our members will discuss whether that's something they want to put on a future agenda, and if it is, then you'll see it come up in a future agenda item. And if it's not, then you have made your voice known and heard, but we ask for the public to understand that during public comment period, our folks cannot make any comment or discussion about those issues unless they are on the agenda. Okay, so what do we do in order to avoid violating the Open Meetings Act? All right, limit your discussions to specific agenda items that are on the agenda that's posted with the Secretary of State, as we talked about earlier. Avoid allowing discussions regarding specific agenda items to wander off course into new issues that haven't been noticed by the public. And don't respond or discuss issues raised during the public comment. And we must specifically identify items for future agendas and communicate those items to TDLR staff so we can get them on those future agendas if you wish to discuss them. All right, so what happens if a violation of the Open Meetings Act occurs? Well, any interested person can step up and say, I think there's been a violation of the Open Meetings Act, and I want to stop this vote. I want to stop the action that the board voted on during that meeting. All right, so it's possible that they could go to court to try to stop a board from taking whatever action they voted on based on an assertion of violation of the Open Meetings Act. And another important thing to remember is that any action that violates the Open Meetings Act is potentially voidable, which means it basically has no effect. So those are things that can happen, and we also have possible criminal penalties. If you knowingly participate in a walking quorum or knowingly participate in a meeting that is closed to the public, you potentially subject yourself to misdemeanor criminal penalties. And the penalties are a fine of $100 to $500, confinement in county jail from 1 to 6 months, or both a fine and jail time. All right, so I think we have talked about the best practices there, and if you need some additional resources, you can log on to these particular websites, or you can always give us a call in the General Counsel's office. Our number is 512-463-3306, and we're happy to provide those resources to any members of our boards or any member of the public that wants more information on the Open Meetings Act. All right, so the Administrative Procedures Act. The Administrative Procedure Act is an act that basically says all state business happens in a certain way. It sets out uniform standards by which we have to do things. And the most familiar way that people are familiar with this act is the rulemaking that we do here at TDLR. All right, so it basically provides for public participation in our rulemaking process. Let's talk about what a rule is. A rule is a statement by a state agency that implements, interprets, or prescribes law or policy, or describes the procedure or practice requirements of a state agency. A rule is a statement of general applicability. What does that mean? Okay, and what that means is that a rule puts into effect the things that we were required to do by statute, either through a program statute or a governing statute that mandates that TDLR operate in a certain way. So rules are the result of procedures that come out of mandates that are given to us by our statutes. And so what you will see in our programs, for example, in our polygraph program, is we have the statute that governs our polygraph program, and then we have our rules that tell us how we operate under that statute. And the public has the ability to comment when we are in rulemaking about these rules, and they have the ability to have input into those rules. Okay, and a rule can amend or repeal, pull back, an existing or prior rule. And a rule, as I explained, doesn't solely relate to internal management or organization of a state agency. It can relate to the operation of a program and requirements for licensees. So in our polygraph rules, you'll see a lot of requirements about licensure and how to get licensed, and who can be a polygraph examiner and who is considered a polygraph examiner under the law. So our rules expand upon our statutory mandates. All right. So what are our sources for rulemaking? Well, as I just mentioned, statute. So if there are legislative changes to statutes, they come out of advisory board work groups. If the advisory board committee decides to appoint a work group to discuss specific issues, often rulemaking can come out of those discussions. Advisory board, just discussion across the board, doesn't have to be within a work group setting. Rulemaking can come from recommendations by TDLR staff from things that they have noticed within the running of the programs, or things that they have heard from the public through their interaction with those programs. There's also a 4-year rule review, which the Polygraph Advisory Committee went through last year. And that 4-year rule review is required of all of TDLR programs. And during that rule review program, the rule review period, the rules will be posted for public comment, and then we will decide whether there needs to be any rulemaking done pursuant to those comments. And anyone can petition for a rule change or a rule amendment or a rule addition. So any interested person can submit a petition to a state agency requesting the adoption of a rule. And an interested person under the law is anyone who is a Texas resident, a business entity located in Texas, a governmental subdivision in Texas, or a public or private organization that is not a state agency but is located in Texas. So if we were to get comments from people who are out of the state, that is not someone who under our statute can engage in a rule petition. But if they were to find someone within the state who wants to assert a rule petition, they could certainly go about it that way. All right, so this is a really long and kind of complicated sort of setting out of what the rule process looks like. The rule process is often very long and it's very arduous. There are many people within TDLR who are involved in that process. The boards are involved in the process, and the commission is involved in the process. So basically this chart takes you from the idea for a rule, it shows you how it goes through the drafting process, how it's proposed, that the public has a public comment period. General counsel's office, the office that I work in, then reviews those comments. We take them back to the advisory board for further discussion, and then the advisory board will decide whether or not they want additional changes to any proposed rules, and if not, they can vote to send those rules back on to the commission. The commission is the final adoption body. So the advisory board can vote to adopt rules and send them on to the commission, but the commission actually has to take formal action to adopt those rule changes or rule amendments. And so this is just another chart that kind of sets out our process on the 4-year schedule. On the 4-year rule review, you'll see a notice of intent to review. The public has 30 days to comment. The general counsel's office will review those comments and make recommendations to the commission. The commission may, from then will decide what they want to do. All right, so on this one we also have resources that if you'd like further information, you're free to go on to those links, or again to give us a call in the general counsel's office, and we're happy to direct you towards more specific information on the Administrative Procedures Act. The final act that we're going to talk about today is the Public Information Act, and the Public Information Act may be the act that's most familiar to the public. And what it does is it basically says that all documents, records, and other information relating to official business is open to the public with some exceptions. So it gives the public access to the business that's occurring within the governmental body. This includes any electronic communication that's created, transmitted, received, or maintained on any device if it is in connection with official business. And the act is liberally construed in favor of granting the requests for information. So one thing that I want to hit on here is something that people often get you see their eyebrows go up when we talk about it. Maintained on any device if it's in connection with official business. So there have been court cases that have said personal cell phones where public business is being discussed is potentially subject to an open records request. So just be mindful of that if you're discussing public business on a device that is not issued by a governmental body. Potentially, it could still be subject to the Public Information Act, and of course that would be something that we would carefully review, and if we needed to, we would seek an Attorney General opinion to see if in fact that information would be subject to the Public Information Act. All right, so what do these PIA requests look like, or open records requests? They must be in writing, and they don't have to have any specific words in them. If you can construe it as being a request for information that is maintained and kept by a state agency, then that could be an open records request. Now, we do ask that the public send us their open records requests to a specific email address. That doesn't always happen. Sometimes I get them, sometimes our other staff gets them, and what we do when we get them is we forward them on to our open records experts. They'll review them and they'll work on fulfilling them if they need to be fulfilled. So if our board members receive any written communications that you think looks like it's a request for information relating to public business, please feel free to forward it to me and I'll forward it on to our open records folks, or you can just forward it on to our open records folks. They're happy to take a look at it and determine whether it is in fact an open records request. So what happens with those requests? Once we determine that they are in fact open records requests, we try to give a prompt response within 10 days. And one thing to be careful of is if you get an email from somebody that says, I want X records on X subject, you can't ask them why they want that information. All right, we can only ask for clarification of what information they are seeking. So again, possibly maybe better if you think that you've received a request for records to just go on and forward it to us, and our open records folks will seek any clarifications if any clarifications need to be made. Now, not everything is subject to disclosure. Whenever we get an open records request, our folks carefully go through it to take out things that are confidential pursuant to the statute. So things that are considered confidential are things like dates of birth, email addresses, certain education documents, and any HIPAA or medical related information. So even though the Public Information Act is fairly broad in terms of what the public has access to look at within our records, there are still things that are considered to be highly sensitive and that will be redacted out or removed prior to producing them to the requester. All right, so that's kind of just a really short overview of open records. Open records can be a much longer topic, but for purposes of our training, we're just going to talk about those few things. And again, more resources here. If you have any questions or concerns, does the board, do the board members have any questions on any of the acts we've presented today? Okay.
No, ma'am, I do not. Thank you so much for the presentation.
Thank you.
Moving on to the next agenda item D. We cannot take any action on the approval of the minutes, so we'll gloss over that and postpone that till the next meeting when we do have a quorum. Moving to section E, public comments. Are there any persons here that would like to address the advisory committee today? Seeing none, we'll move on to the next item of business, which is section F, staff reports. Briefing from the licensing division.
Good morning, Chairman.
Good morning.
And board member. Lisa Hodek, licensing manager. And my report has fiscal year 2018 and through the third quarter for fiscal year 2019. And as you can see, we're still getting in a few applications for new licenses, as we've issued 18 for 2018, and for this year we're up to 11. The trainees, we've done 12 last year and then 10 for this year. So combined, our overall total population for this year is we have 258, and that includes both license types. Things are running well, kind of slow and smooth, but that's okay. Renewals are still coming in, and that's really about it. So I'll be glad to answer any questions that you might have.
Just one question,
Mhm.
just out of curiosity. Is that number about, have we been staying about 250 as far as licensees?
Yes, yeah,
Okay.
not
We
a
haven't grown or gotten
a
smaller?
little
shrunk?
bit here and there, not a big growth.
All right, just out of curiosity.
But we are still getting a few applications in, so there's a little bit of growth.
All right. No other questions from me?
No, ma'am.
Thank you.
ma'am. Staff report from Customer Service Division.
Good morning, advisory board members. My name is Tuan Nguyen. I'm the customer service manager for this program. So as you can see, since the last time we met, the stats for polygraph examiners have roughly been the same compared to fiscal year 18 and 19. We had that small, slight decrease in March for that data, but other than that, very similar statistics and then similar questions. People are still asking about how do renewals, their statuses on their renewals, and then once usually we'll give them a status update that the license has been issued, then the customer's really complete and satisfied with the resolution.
Okay.
And I'll be happy to answer any questions y'all have for me.
Any particular questions that are being submitted to the Customer Service section, division?
I wouldn't say anything that really stands out. Most of the norm from the community for polygraph examiners is really just renewals.
Okay. No other questions for me. Thank you. Staff report from the Enforcement Division.
Good morning, Chairman Espinosa and fellow board member Ms. Collier. My name is Jaime Uribe. I'm a prosecutor with the Enforcement Division, and I'm here to bring you the enforcement plan, the enforcement report. I'm going to talk about three things: the statistics, the introduction and overview of the Enforcement Division, and the enforcement plan and the penalty matrix. First, I'd like to talk to you about the statistics. I know you have the stat there in front of you. I just want to highlight a couple of the numbers. Through April fiscal year 2019, we've had 8 cases opened in your program. Compared to TDLR as a whole, there were 7,136 cases open. And in your program, the number of cases resolved were 5, and in TDLR as a whole, there were 6,613 cases resolved. In your program, there was 1 final order, and at TDLR as a whole, 1,137. The total penalties assessed for your program, $2,000, and for TDLR as a whole, $1,906,570. And the penalties collected for your program was $2,000, and TDLR as a whole, $956,162. That's approximately 50%. And that's what we've been observing the last couple of years, that we collect 50% of the penalties that are assessed. In your comparison to other programs regulated by the department, your program is relatively small. However, that does not take away from the fact that your program deals with very important and very significant subject matter. You have relatively low complaints in your program, which tends to indicate that your licensees are generally compliant. Do you have any questions regarding statistics before I begin an introduction and the overview of the Enforcement Division?
I do not. Go ahead. You can continue.
Okay, the Enforcement Division is responsible for the investigation and the the resolution of complaints filed within the department. The department has has administrative assistants, they have legal assistants, investigators, and prosecutors. The enforcement division has specifically 3 sections: intake section, we have the investigation section, and we have the prosecution section. The intake section substantiates whether or not the department has jurisdiction, and they also provide the initial research on the complaint. They're the ones that decide whether or not a complaint is going to be open for investigation. Sometimes intake will receive a complaint and they'll close it right off the bat immediately because the department does not have jurisdiction. An example of this would be like in cosmetology. Someone may complain that they received a bad haircut. Well, that's not something we regulate. However, the department does regulate whether a cosmetologist is licensed, whether a cosmetologist is properly trained, whether a cosmetologist properly cleans and sanitizes the metal implements they use while performing cosmetology services. But we don't regulate bad haircuts, so intake closes the case right off the bat. Sometimes intake may need additional information and they reach out to the complainant. They may need additional information to establish the department's jurisdiction, or they may need information to establish an alleged violation. So they send out a letter to the complainant requesting further information. If the complainant does not respond back to the department, intake will close the case. Sometimes the cases are filed anonymously. So if intake needs information regarding the jurisdiction, whether or not an alleged offense occurred, obviously they would close the case immediately because there's no one out there to reach out for the additional information. However, if there's sufficient information in the complaint, the case is then transferred to the investigation section. The investigation section, the assigned investigator tries to develop a specific set of facts establishing a case. They do that by obtaining documents, interviewing witnesses. Sometimes they do on-site inspections. Once they're done, they file not a police report, but a report, and then that report is then transferred, that complaint is then transferred to the prosecution unit. Now, the prosecution unit is responsible for the proper disposition of the case. Once a prosecutor receives a case, they read everything. They review the whole case. Statements, they look at the documents, and then if sometimes they need information, additional information, and they reach out to the investigator and they try to establish whether or not an alleged violation occurred. The prosecutor is the one who decides how the complaint should be resolved. Generally, complaints come from 3 different sources. We have a consumer complaint, we have a department complaint, and we also have a complaint based on the applicant's criminal history. Now, consumer complaints come from outside of the agency. They come from the consumers, people within the industry, sometimes from municipal officials. If intake opens up a case like that, it's forwarded to the investigative section. They do what they have to do, and then they transfer it to the prosecution section where the case will be resolved. Department complaints are complaints that arise from on-site inspections from the field operations division, and also sometimes from proactive investigators. Now, these cases are generally transferred from intake directly to the prosecution section because the underlying evidence has already been developed by the inspector and/or the field investigator. Now, criminal history complaints arise from the criminal background checks of licensed applicants. The criminal histories of these applicants is generally initially reviewed by the licensing division. If the criminal history shows a crime or an offense that may be, would be possible not to allow the person to be licensed, licensing division forwards that case to the prosecution section. At prosecution section, we have two attorneys, specific attorneys that handle these specialized complaints. The prosecutor would get the case, the complaint, review the criminal history. If he could not immediately clear this person for a license, they will request a full investigation on the criminal history of the applicant. Once that investigation is complete, then the prosecutor will decide whether or not to deny the license and/or revoke a license. It depends on the facts. Now, being consistent in investigating and resolving complaints is essential to have effective enforcement. And we strive to be consistent. And we do this by utilizing 3 guidance documents that are regularly updated. The first is the Complaints Resolution Procedures Manual. In that manual, there is a set, detailed, and standard procedure on how to handle complaints from intake to investigations and then ultimately to the prosecution section where they're ultimately resolved. The second document is the enforcement plan, which lists the penalties and also the license sanctions that apply to certain offenses and certain alleged violations of the statutes and the rules that are enforced by the department. Now, the third document is the Criminal Convictions Guideline, which sets out for each license that the department regulates specific convictions that may make an applicant unsuitable for obtaining a license. And it also includes information how that specific offense relates to the specific license that the applicant is trying to obtain. Now, does anyone have any questions regarding this introduction before I go to the overview of the?
I got one out of curiosity. I guess I'm just a curious person, huh?
That's fine.
As far as department complaints, you talked about field inspections. Are those proactive inspections that are conducted, or are those based off of a complaint from a consumer?
No, there are some proactive where inspectors go out in the field and, for example, certain programs need to be inspected by statute every 2 years. For example, you go to a cosmetology place, a salon, an inspector must inspect that business, the salon, and then they issue an inspection report. And those type of inspection reports are generally sent to us from intake directly because the underlying evidence has already been established. But there could be some complaints also. People complain, and then we sent out investigators, and they make an inspection, and then they file their report. It could be both ways.
All right, thank you.
Thank you. Now, regarding the enforcement plan and penalty matrix, in all cases, it's the prosecutor who decides how the case will be resolved. A prosecutor has different options on how to resolve a case. One option would be, for example, if a prosecutor gets a case and determines there's insufficient evidence to proceed on the complaint, they will issue a closing letter, and it's sent to the respondent advising him or her that we found insufficient evidence to proceed. And then if we have a known complainant, we forward a copy of that closing letter to him or her so they would know why we closed the case. Another example would be a warning letter. There could be a violation, but we decide to issue a warning letter. An example of this would be, for example, someone's advertising on Facebook that they're a polygraph examiner, but they're unlicensed. Obviously, that's a violation because we regulate when a person is licensed in your program. So we might decide to issue a warning letter. We use that as a teachable moment. We reach out to the person, and the person removes the offending advertisement, and there's been no harm to the Texas public, and economic or otherwise. We may issue a warning. We use that. We use it to basically tell the individual, hey, you want to become licensed? Well, this is what you have to do. We want the person to be compliant. We direct them to the TDLR website. We tell them it's user-friendly, how to look up the program, how to look up the statute, the rules, how to look up the application, where it is so you could download it. We give them all the information. We give them customer service number because we want to balance two things. We want to make sure the Texas public, there's no harm to the Texas public, and at the same time, we want this person to be compliant, get on the program, and then also earn a living. So balancing two things at the same time. Now, another option is the Notice of Alleged Violation, commonly referred to as the NOAV, and this is our charging document. And this is where we tell the respondent what rule or statute under the Texas Occupation Code or the Texas Administrative Code that we believe is the person violated. We have to give notice. We tell them the facts, the statute, the rule that we allege is violated, and we also set out in the charging document the administrative penalty or sanction that we're seeking based on the penalty matrix. And the administrative penalty is a monetary fine paid directly to the state, while a sanction is an action upon a person's license. It could be anywhere from denial of the license, denial, revocation, probation, or suspension of a license. There are several factors that the prosecutor uses in determining the amount of the administrative penalty or the level of sanctioning that is included. The first one is the severity and seriousness of the violation. The second one is whether the violation was willful or intentional. The third is whether the respondent acted in good faith to avoid or mitigate the violation or to correct the violation. The fourth was, does the individual have a history or pattern of violations? And what penalty or sanction would deter future violations? And that's, there's a general deterrent effect. It notifies other people in the program or the public that if they engage in similar conduct, that they may face a similar type of sanction. And it also has a specific deterrent effect against the respondent because he knows that in the future, if there's another alleged violation, that he's going to be held accountable, he or she is going to be held accountable. And then finally, the last factor is what does justice requires, because sometimes certain cases have nuances or they don't all fit in a box. So there's, depending on the case, that's why the sixth indicator is there, factor, is there. Once the NOV is sent out, we allow time for the respondent to contact us. If the respondent contacts us, and sometimes they do, and they say, you know what, I committed a violation. How can we take care of this? So we arrange a settlement. We hammer out a settlement agreement. Once we settle the case, we proceed with an agreed order. The agreed order is a settlement agreement where we notify the respondent what violation of rule or statute that has occurred, and we also set out the amount of the administrative penalty and or sanction, and then we sent this agreed order to the executive director for signature. And once the executive director signs it, the agreed order is final. Sometimes we don't hear from a respondent. They don't contact us, and they don't request a hearing. So we proceed with a default judgment in that particular case. A default order usually goes to the executive director when we don't have contact with the respondent, or we have little contact with the respondent. And there's a certain procedure that we have to follow to ensure that the respondent has notice. Same as when we have an NOAV, we have to give notice throughout the process, because we never want someone to come back to us and say, what is this? What are we talking about? So we follow those specific guidelines. Sometimes a respondent may request a formal hearing. If a formal hearing is requested, the hearing is held before an administrative law judge and an ALJ before the State Office of Administrative Hearings, or SOA. The ALJ renders a decision, it's called the proposal for decision, and that's not the final decision on the case, because it's the commission who decides how the case will be final. And after there's a hearing at SOA and the PFD is issued, all parties are notified of the date of the commission hearing. There, the commission will consider the decision rendered by the SOA judge in the PFD. And then both parties, the prosecutor and also the respondent, has a right to present their case before the commission and argue their case regarding the PFD. After the commission makes a final decision, a final order is issued to both parties. If the respondent believes that an order of the executive director or an order of the commission has an error, that person has a right to file a motion for rehearing no later than the 25th day after the order is signed. Does anyone have any questions on that part of the enforcement plan before I go into the penalty matrix?
Whenever there's an affirmative finding and the final disposition is handed down in whatever capacity through the administrative judge or what have you, is that information public information that's posted onto the TDLR website, or is that something that somebody would have to do an open records request?
You know, I haven't seen it on the website, but I was wondering if
Mary Winston, TDLR, you can get it from a public information request.
Okay, thank you.
Okay. Now, regarding the penalty matrix, in your program, we have 5 classes of penalties and sanctions. We have A through E, A being the least severe, E being the most severe. And you can tell as the fines go up. All the classes come with an administrative penalty assessed. Depending on the nature of the violation and the class, sometimes a suspension or revocation of a license can be assessed as well. It can be in addition to the penalty, or it can be instead of a penalty. It all depends on the specific facts. Now, in a Class A, the penalty ranges between $100 and $2,000. These are mostly administrative violations. For example, failure to notify the department of changes required by the licensee. In a Class B, the penalty ranges between $500 and $2,500. An example will be when a licensee administers a polygraph examination, but the license is expired. In a Class C, the penalty ranges between $1,000 to $5,000. This involves unlicensed activity. And when an individual administers a polygraph examination and the individual is unlicensed. In Class D, the penalty range is between $2,000 and $5,000. An example would be making willful misrepresentations to try to get some business. And finally, in the Class E, the penalty range is between $3,000 to $5,000. An example will be a failure to abide by an order of the commission or by the executive director of our department. Do you have any questions?
If a customer or the public out there would want to find out if any of the Texas Polygraph Examiners that are licensed under TDR have been complained on or have a sustained complaint, is there an avenue that they can go through in order to obtain that information other than an open records request?
Not that I know of. I know that they can look up the licensee information on the website.
Mary Winston again, TDLR. We also, final orders are posted on the website. Some jokingly refer to it as the wall of shame. You can just take a search there, or you can look up a licensee and you can find disciplinary action. If it's a final order, it's public information, it's out there. If you want to, on the website, if you want to have more specific information, then you make a request and you can get that information from our public information section.
Thank you, Mary. No other questions for me.
Well,
Thank you so much for your presentation.
Well, thank you.
Report from Education and Examination Division.
Good morning, Chairman and Board Member. My name is Lorraine Srove, and I will be doing the report for the Education and Examination Division. You have been provided our statistics, and also I wanted to highlight that there will be an exam review committee meeting on September 26th and 27th, and that is the annual review of the exam items. In the statistics, you've been provided numbers through the month of May 31st, 2019. You have the exam statistics. You also have the breakdown by exam type, which includes the written, scenario, and practical. These are for both fiscal year 2018 and through May 31st of 2019. And then the final statistics you've been provided is that of the continuing education courses. And we did have a continuing education provider audit in December on one of our providers. That's the information that's in the report. If you have any specific questions, I'd be glad to answer those for you.
What prompted this audit?
We have a auditor in our department now. He started in 2018, and that is going to be a process that we do for all continuing education providers. There wasn't any specific prompting for that other than we want to do each industry and do at least a percentage of each one, that hopefully by the time we get through 1 to 2 years that we've done an audit on every provider. Anything else?
No, ma'am. Thank you so much for your
All
presentation.
right, thank you. Have a good day.
Report from Regulatory Program Management Division. Russ, good morning.
Good morning. I'm Russell Tolley. I'm in the RPM division, and I'm just going to give you a brief overview of the outreach events that we've attended. It's one of the primary functions of the RPM division. We're also research aids as case questions arise. I last attended the American Polygraph Association meeting that was held here in Austin I believe it was in August of last year. It was a fantastic meeting. I don't know if both were you, I know Manny was there. No, it was a wonderful occasion. Got to meet a lot of people, polygraph examiners from all over the world. So I was able to host a table representing TDLR and answer many questions about licensing in Texas. I'm available for other events as I'm invited. If you know of any, please forward them to me. Be happy to attend.
I know there's one next week in San Antonio, the Texas Association of Law Enforcement Polygraph Investigators.
Right, Telepi.
Will be hosting a 3 or 4 day training in San Antonio.
Mhm.
You haven't received an invite for that?
I haven't. I normally attend, or at least for one day, and say hello, but I'm not planning to at this time. But if I get an invite, I'll be happy to.
Okay.
Any other questions? Thank
No,
you
sir.
very much.
Thank you so much. Last but not least, Executive Office.
Good morning, Presiding Officer and Ms. Collier. Mary Winston, TDLR, I'm going to be giving the Executive Office report. Since our last meeting, we have had personnel updates, changes. I want to start with that. When you were last here, we had Nick Voenis, who was the Deputy Executive Director, along with Carla James. Nick has retired. It was a surprise to us. He made the announcement, and he was tired of traffic, and I'm so jealous. So he retired, and we have replaced him with an awesome new team member. While you've been here under your tenure, the chair of our commission has been Mike Aris-Mendez. Well, his tenure ended as chair of the commission, and he has agreed and accepted a position and come on as the new Deputy Executive Director along with Carla James. So this has been an awesome opportunity because there are many things he saw as the chair of the commission, just part of the commission, period. But now I've worn out that ducks paddling on the water smoothly when all the feet are moving underwater. Now he sees all of our feet moving underwater, and he's, part of all that action. So he started, and we've welcomed him, and he's jumped immediately in. And it's just a pleasure to have a former chair come on as a staff member, and he really just has a panoramic view of everything. So, as you both know, we have just completed the 86th legislative session. It was definitely a successful session for us. Our executive director, Brian Francis, is tireless. Our deputy executive director, Carla James, is like a fiscal budget guru. And then with the addition of Mike Aris-Mendez, he came in, and I think that first date, he had to stay at the Capitol all day, and that was his address for the whole session. He was there more hours of the day than he was not. So that executive team, along with our government relations officers, we have Steve Bruno in the audience, Eric Beverly, and Colleen Tran, various staff members who had to pitch in with legislative session duties along with their other duties. Very successful, and it actually resulted in 21 of our 29 strategic initiatives moving forward. That is a percentage over 70%. And when we look at that in relation to the number of bills that are presented during the session, there's less than 20% of the bills that are presented that are actually passed. So it was a good session. We've also grown again, and thanks to Carla and all the efforts of everyone, but I know she works out the money, and we appreciate her for that. We will have more staff and more finances thanks to the legislature to take on 2 new programs. Currently, it's motor fuels metering and motorcycle safety. So that's a brief update. More will come as we move forward, as you know. Finally, I wanted to give our website traffic, which we have as communication outreach statistics. For your program in the last 6 months, thanks Josh Schroeder, Polygraph Examiners have had 5,114 views, an average of 28 a day. Considering the size of this program, that's a good amount. 52% of those visit from a desktop computer, 46 from a smartphone, 2% from a tablet. And the top reasons for visiting the site: exam information, administrative rules, polygraph examiner education, FAQs, and forms. And that's the end of my report. Do you have any questions?
I do not.
No, ma'am, thank you.
Oh, and thank you all so much for making it. These things happen, we all know, and I just want to give a special thanks to Ms. Collier, and just being so gracious for understanding that when you had something that came up this morning for another member, you were just like, stuff happens and that's fine. So thank you so much.
Moving on to agenda item G, recommendations for agenda items for the next meeting. As the polygraph advisory committee members, I guess individually, we can submit any agenda items that we would like to put on the next agenda, and we'll direct those to Ms. Luna, if that is okay. And as far as the date and time for the next committee meeting, I would ask Ms. Luna if she can poll the members, the committee members, to see when and where would be the most convenient time for us to meet and have a quorum, and take care of any actionable items that may be on the agenda. Other than that, I have no other information to provide, and that concludes the agenda items that are listed on the agenda. And unless there's any other questions, I will close the meeting.
Thank you.